For judgment, item 25, criminal appeal 296/2019.
Yes. So we have dismissed the appeal.
Obliged.
Item 26, criminal appeal J 1/2023.
But, like to mention, oh, judgment, sorry. So conviction converted to 304 part 2, 10 years jail sentence to be adjusted against period already undergone.
Mention.
Item number 6 has become infructuous, my lord. Matrimonial matter, my lord. They have settled it among themselves.
Why it has become infructuous?
My lord, they infructuous because they have settled it in the family court, my lord.
All right, Mr. K. Bhattacharjee, Nayak Counsel appearing for the applicant stroke appellant submits that the parties have amicably settled their dispute and therefore the appeal has become infructuous. In view of the above, uh, the appeal as well as the connected IA stands disposed of as infructuous.
Lovely.
May I please, your lordship? With regard to item number 21, my lord.
Yes,
My lord, we're making a joint prayer. Since this bench may not be available in the next week.
no, it will not be.
It will, we may not be completed today. So I'm praying that the matter will be listed immediately after the vacation, my lord, on 18th or 23rd of July.
21, on the prayer of Mr. B. Prasad, Nayak Counsel appearing for the appellate, hearing of this matter is adjourned with a direction to list this case for hearing again on 18th of July,
18th of July.
18th of July 2020.
Okay. It's for the NIA.
You are there for the respondent.
Yes,
Mr.
D for Advaj.
D. Vardhan and counsel is present for the respondents. Bracket Nia.
All right.
Yes.
Daily list for admission at 1.
Got into the same platform.
No.
The problem. Similar view was taken.
Item 2.
মই ভাবিছো মোক কৈছিল দিছিলো
Who is a jail appeal? The amicus is not appointed. It has come up for the first time.
This appeal has been preferred from the jail. Therefore, an amicus curiae is required to be engaged in the matter, registered to do the needful and list this case again for admission by reflecting the name of learned amicus curiae in the call list.
Item 3.
On the last occasion, there was a delay and that was condoned. Yes. Now it has come up. for
We'll admit the appeal.
Lordship. POXO matter.
Heard Mr. A.M. Ahmed Nayak Counsel for the appellant. This appeal is preferred against the judgment dated 12/1/2024 passed by learned Special Judge bracket POXO bracket close in connection with Special bracket POXO bracket close case number 04 oblique
to other accused person under section 302, 326 and 341, my lord. And I am for the accused number 2, lordship. Judgment is that, my lord, page number, my lord, 49 onward, my lord, annexure 6. And operative portion is at page number, my lord, 105, my lord.
Padmadhar Sivaram Tilak.
My lord, may I read, lordship? After perusal of the entire record, taking into consideration the submission of the learned counsel for the parties and accused persons, parties and accused person 1, 2, and 3, and also considering the offense committed by the accused person under section 341, 326, 302, and 34 IPC, I sentence the accused number 1, 2, 3, and 3 to undergo rigorous imprisonment for life and to pay a fine of rupees 15,000 each in default simple imprisonment for 1 year under section 302 of IPC. A further sentence to undergo rigorous imprisonment.
Heard Mr.
H. Rahman, lordship.
Is H. Sharma. H.
Rahman.
Rahman. Right, counsel for the appellant. Also heard Ms. S. Jahan Lana, APP Assam appearing for the state. This appeal has been presented by one of the accused persons, namely accused number 2, assailing the judgment and order dated 18/11/2023 passed by the learned Session Judge, Lakhimpur in North Lakhimpur in connection with Sessions case number 78 bracket NL bracket close of 2013, convicting the appellant and 2 other accused persons under sections 341, 326, 302, 34 IPC and sentencing each of them to undergo rigorous imprisonment for life and also to pay a fine of rupees 15,000 each with default stipulation. Inter alia sentenced each of them. We peruse the grounds taken in the memo of appeal, admit the appeal, call for the LCR, issue notice returnable in 4 weeks since Ms. Jahan has appeared and accepted notice for respondent number 1. No formal notice is required to be sent in this case.
And there is an IA for suspension of sentence, lordship.
We'll consider it in the meantime. So in the previous, I also in the meantime, the state may file objections. Here also state may file objection.
Obligable.
For order item 8. Next slide, please. Give me the address. Oh, this is not mine. It's 7 to number 11?
আমি যে রেকর্ডটা চেক করব
Oh,
রেকর্ড চেক করবেন
Could use next.
Yes, please.
Here in this case, lordship, the appellant is convicted under section 6 of
That it belonged to, I was directed to obtain instruction. I'll verify my records. Let the matter come up in the coming week, my lord. POXO matter.
Mr. A. Ahmed is learned counsel is present for the applicant on the request of Ms. B. Bhuya, learned APP Assam. This appeal, this matter is directed to be listed again on 22nd of May 2024 as a fixed item. So as to
Right.
enable her to obtain necessary instruction.
Item 9.
may I pay this matter may be taken up after some time, lordship. Item number 9.
There my objection
Okay.
is there.
Item 10.
May it please, Lordship. This matter relates to my lord POXO Act, my lord, wherein my
Mr. P.K. Muni, learned counsel is present for the applicant stroke appellate. Ms. S. Jahan, learned APP Assam submitted by Monday. The officer in charge of Hajar Police Station will produce the service report as proof of service upon respondent number 2 Therefore, this matter will be listed again in the next week. Prayer allowed that the matter be listed accordingly.
Much obliged.
Item 12.
Objection, I is pending. I don't know whether notice has been served or not.
वही क्वेश्चन है
मैं कौन सा नहीं
Here also I'm told service issue is there, but we don't have instruction. I will get it soon.
Order dated 1/3/24. Okay, where is it?
All right, Mr. Das, we'll have to wait. Notice has been sent on 1/5. Mr. Ajay Das, Lana Amicus Curiae is present for the appellant. Ms. S. Jahan, Lana APK Assam has appeared for the state. Office note indicates that upon implement of the informal appeals to respond number two, notice was issued only on 1/5/2022. Therefore, await service report on the respond number two for another 3 weeks.
Deeply obliged.
Item 14.
Service, POXO.
Swapna লৈছে
Mhm.
Swapna লৈছে
Mhm.
Swapna লৈছে
তাৰপিছত সেইটো হ'ব
deep duty.
এই দুটি দেখা ন
কিমান দিলে?
Till 8 days or so.
POXO নে?
So section 6.
Delay of
Your Lordship, here's a decision convicted case under section 6 of the POCSO Act, Your Lordship. And moreover, a continuation delay period of 8 days has been filed, Your Lordship.
delay of 8 days will conduct.
8 days not.
8 days.
Your name, please?
N Milli, Your Lordship.
And?
N Milli, Your Lordship. Your Lordship, kind submission before Your Lordship. The accused in the jail and also has gone bypass surgery on the previous occasion. So a medical report can be called from the concerned jail authorities.
We'll ask the appeal to be listed on Monday,
Oh,
then you make
okay.
this page. Today it has not been registered yet. You've then heard Mr. Emily and counsel for the applicant. Also heard Ms. S. Jahan and the application appearing for the state. The applicant hearing was convicted by the judgment and order dated 22/11/2023. Passed by Lana Sessions come special judge POCSO. Kamru bracket M bracket Guwahati. In special case, session special case number 46/2022. Under section, he was convicted under section
6 of the POCSO Act and
6 of the POCSO Act and inter alia and sentenced to undergo
20 years, Your Lordship.
rigorous imprisonment for 20 years and also to pay fine. The
Your Lordship,
applicant
25 years, Your Lordship. 25 years.
and also to pay
20 years. Oh, no, 25 or 25 years.
fine of rupees 20,000. The applicant has assumed the interim judgment that filing appeal before this court. However, since there was delay of 8 days in preferring the appeal, the instant IA has been filed to prayer to condone the delay. We have perused the grounds stated in the application explaining the delay. Mrs. Jahan, our APP, submits that she has no instructions to file any objection opposing the prayer made in the IP. Considering the fact that the applicant has a statutory right of appeal against the judgment and order of conviction, and in view of the explanation furnished in the IP, we are of the considered opinion that this is the 5th case where the delay of 2 days in preparing the connected appeal deserves to be condoned, ordered accordingly. Office to office to register the connected appeal and list for admission on Tuesday. I extend this one.
Much obliged.
Here you make the prayer.
And there is a delay, my lord.
Even delete na.
269 days. 269 days, my lord, service awaited, my lord, as per the office note. Service is awaited as per the
269.
office note, my lord.
But this is what POXO.
My lord, no, not POXO, my lord, 376(3), subsection 3,
Was 376.
subsection 3.
But it is tried by the POXO court.
Initially, it was Salzer stream, my lord, but thereafter 376(3) as the punishment is on the higher side, my lord.
You want to take fresh steps?
My lord, as my lord deemed fit.
Yes, otherwise there will be delay. Heard Ms. S.G. Burwal and counsel for the applicant. Also heard Ms. S. Jahan and the APC Assam appearing for the state. Perused office note dated 30/2024, which goes to show that service report is awaited on the respondent number 2. In order to avoid any further delay in the matter, we grant liberty to the applicant to take fresh steps for service of notice upon the
My lord,
respondent number 2.
we have served through the PP also, my lord, as per the last court's order.
But this is 376. That is not the requirement under Deepak Nayak.
376 is not.
No, only POXO.
These before to by the 3, subsection 3. Like
Oh,
it is. My lord, it
Deepak
is
Nayak is
required.
only-
Because my lord, it will
Subsection-
be required. Subsection 3, yes.
Subsection 3 is there. So
Where is the
perhaps
notification?
some-
Deepak Nayak.
Huh?
Mula, what now? Anand.
Deepak Nayak.
Yes, 370 is notice has to be there. By registered post, steps by registered post will be ready within a week from today. The applicant is also granted liberty to take steps for service of notice upon the respondent number 3 to the officer in charge of concerned police station. The steps will be routed through the office of the PP Assam.
Obliged, my lord.
We'll have to do something in the office to streamline all this.
Why don't you do it?
Today only we will do something with the public prosecutor.
Please do it.
Item 17.
Yeah, please, your lordship. Okay, there is a delay of 3 days, lordship. Service complete.
Service is complete here. He is appearing.
Delay
Delay
of
of
3
3
days.
days.
Will condone the delay. Heard Mr. J.P. Moore, learned counsel for the applicant, also heard Ms. S. John, learned deputy Assam, appearing for the state, Mr. N.J. Sharma. Learned counsel is present for the respondent number 2. This IA has been filed with a prayer to condone the delay of 3 days in preferring the connected appeal against the appeal judgment in order dated 19/12/2023, passed by the learned special judge. Bracket POXO, bracket close, comma, Karbi Anglong, comma, in connection with POXO case number 19/2022. We have perused the explanation furnished in the application. Ms. S. Jahan, Nair, APP Assam, as well as we have filed objection. As well as Mr. Sharma, Nair, counsel for the opposite party, number 2, submit that they do not have any instruction to file objection opposing the prayer made in the IA. In view of the above and considering the explanation furnished by the applicant, we are of the view that the applicant was prevented by sufficient cause from filing the appeal within the period of limitation. First of the delay of 3 days in preferring the appeal, therefore stands condoned. office to register the connected appeal and list for admission. Highest and discipline.
Obliged.
This is creating an application come up for the first time. Notice me go. POXO matter. Section 6, 20 years.
It has come up for the first time, no?
Mr. D.K. Bhattacharya, Land Council for the applicant. This IA has been filed under section 389 bracket 2 bracket close of the CRPC with a prayer to suspend the conviction and jail sentence of the applicant awarded by judgment and order dated 9/2/2023, passed by the learned additional sessions judge, special judge, bracket code, bracket close, POXO, in bracket POXO, comma, Borpeta, in connection with
Other counsel for the other appellant can take benefit of it if he gets bail. Otherwise, the PP can place the order before.
No, we are taking it up to together. We can do it at 2 o'clock. if you want.
On other day, because other counsel probably he will not be ready if.
You are not for the other. Who is the counsel for the other side?
Sectorally.
I will inform, I can inform him.
Call him or we can fix a date. Who is the counsel?
That I have to check the names. I will.
Sectorally, Swasan? Sectorally?
Heard Mr. Yaman and counsel for the applicant also heard Ms. S. John, Lavin OPP Assam declaring for the state. It appears that the co-accused was convicted by the common judgment dated 28/2/2023 and order dated 4th and similar sentence was awarded to him by the order dated 4/3/2023, passed by the learned additional sessions judge, Bilasipara, Dhuburi, in connection with sessions case number 330 of 2014. It has also been brought to our notice that the co-accused has also preferred an appeal, which is pending before this court, along with a similar application seeking suspension of sentence, but the matter is not listed before the court today. Considering the nature of issues involved and the consequences and order passed in this case, and the consequences that may ensue upon the other accused persons in an order passed in this proceeding, we are of the view that both the matters should be taken up together as such, registered in this case along with criminal appeal number.
That I will give after.
Appeal number so and so. Do you want any specific date? Any date?
Lordship may fix it any date.
After a week.
Obliged.
Supplementary list for orders, I think 27.
In this case, while notice was issued to the S1 number 2, my lord, victim's mother, my lord, informant. They have entered appearance, my lord. Filing Wakalatama and also an affidavit.
Lordship, we have filed our objection. And service is also complete. My learned friend is at.
So you are pressing the IA today.
I basically were there. Actually, they were husband and wife, my lord.
No, no, are you pressing the IA today? You want to argue the IA?
I basically because they yes, my lord, basically,
What basically we are.
yes,
asking
I
whether-
on the ground there.
That's another matter. So we'll take up the IA then. The IA, what is the IA number?
Oh, Lordship, 572.
Yes.
No.
All right, what is
This is under quotation. This is the statement. So and so, Iman on 27/6/17 at about 6:45 PM as per the previous plan, I called Anwar Hussain Laden. Thereafter, I, along with my co-blazer Khairul Islam, removed the wearing shirt of Laden and gagged his mouth and strangulated him to death. We have kept concealed the wearing shirt with which we gagged his mouth. Now I can show the said shirt of Laden. This part, we have kept concealed the wearing shirt and we can show this. Now this part is 27. Accordingly, the statement of accused Saiful Islam was recorded. Exhibit 9 is the said statement of accused Saiful Islam dated 10/7/17. On 10/7/17, during my custody, accused Khairul Islam stated to me, on 27/6/17 at about 6:30 PM, I arrived at my house from Jaunamok and met Saiful Islam on the way. Having seen Anwar Hussain Laden standing on the road in front of his house, I kept myself hiding in the betelnut garden of Amjad Ali and asked Saiful Islam to call Laden. Accordingly, Laden was tactfully called and brought to the betelnut garden. Thereafter, I and Saiful Islam removed the wearing shirt of Laden and gagged his mouth with his shirt. But as Laden was resisting, I and Saiful Islam pressed his neck. As a result of he died. We have kept concealed the said shirt of Laden in the jungle, and I can show it. So this part is 27. So it shows that they have got the information from Saiful already. Accordingly, I recorded the said statement of accused Khairul Islam. Exhibit 10 is the said statement of accused Khairul Islam. On being led by Khairul Islam and Saiful Islam, I, along with them, went to the place where they had kept concealed the wearing shirt of accused Anwar Hussain. Both the said two accused persons showed me the shirt of deceased Anwar Hussain, which they kept concealed inside the jungle of the betelnut garden, nearby the place of occurrence. Accordingly, I seized the shirt in presence of the witness and the accused persons. Shirt was identified by Ilyas Ali, the father of the deceased. I seized the shirt of the deceased as recovered by the accused persons in presence of witness by preparing Exhibit 2, seizure list, wherein I also obtained signature of the accused persons. Exhibit 2(3) is the signature of accused so-and-so. Saiful Islam 2(5) is my signature. I also recorded the statements of the seizure witnesses. Material Exhibit 1 is the said shirt, which was recovered by being shown to accused persons from their single nearby place of occurrence. Jungle nearby the place of occurrence. I collected the post-mortem report of the deceased Anwar Hussain. At the end of the investigation, I submitted charge sheet. So yes. Now, my lord, at this point, I will take your lordship to the exhibit 9, no? 9. Huh? Page number 92, my lord. This is relevant here to consider another aspect. Exhibit 9 at page 22. 92. Lordship has seen, my lord. What will be the bearing of this particular line, this sentence? It has to be construed. Page 92. Statement of Muhammad Saiful Islam. Yes. It says, this is under section 161. They have recorded. Page 92, my lord. Exhibit 9. My name and address, Lordship got his mallet. My name and address mentioned above are true. I am 23 years old. my statement in connection with the above mentioned case will be the same as my earlier statement. Let me repeat, my lord. He says in connection with this case, my statement will be the same as my earlier statement. And then he says, around such and such time, this pre-planned way, this part comes. Does it not indicate that similar statement, this information was already given by him? He says the same thing, what I am saying.
No, that point is taken. We understand it, but there is a difficulty.
There is a two-part, Mallory. If I
There is a difficulty.
Yes.
We are putting it to you.
yes.
This is not only a case where based on information, police went and recovered. This is a case where both of them had led the police to this spot to recover the shirt. Right? This statement alone does not lead to recovery, because statement, they say that we can show you where it is. Correct? So this statement is not a statement of disclosure. This statement only says
Yes.
we know where the shirt is kept,
Yes.
but the shirt was recovered on being led by the two accused persons. At that time, they were together.
My lord, now then, yes, this part, how you can take it? What will be the legal implication?
You please tell us.
What will be the legal implication? My responsible submission would be, my perception to this particular issue would be that firstly, you get the information from me, then you take me along, and if you find that my statement is correct, in a particular place I said discovery was made, then it leads credence that I have said something and it comes in, that information comes in under 27. But leading, before leading, you must have the information for the first time. So if you get it from someone already, then you take me along. When the statement goes, then my accompanying and showing
No,
would
Mr.
have no bear.
Blanca, please appreciate this query. We have understood your point.
Yes.
And that is logical. There is no dispute about it.
Yes.
Somebody says, I have committed a murder and the dead body is buried behind the tank in such and such place. Then another accused statement is recorded and both of them are said to have adduced evidence under 27. No, not possible. But here they said that this happened and I can show you where the shirt is.
My lord,
Yes.
yes.
He did not, see, his information was not sufficient for the police to go and recover the shirt. Neither in case of Khairul nor in case of Saiful. So that is why the police took both of them next morning to a place which was 30 kilometers away in the jungle and asked them to show where the shirt is kept. It is at that time both the accused persons led the police to recover. So recovery was not made on the basis of Exhibit 8 and 9. Exhibit 8 and 9 are mere statements recorded by the police. Information that they know where the shirt is.
Yes.
But they did not say where it is.
No, my lord.
If had they said where the shirt is, then your argument will come into play. That we agree. But here they only say that we can show you where the shirt is. So there is nothing disclosed to the police except that they were aware where the shirt is. Right? So next day, both the accused persons, they led the police to that place. They physically went with the police, led the police and showed
Yeah,
where the shirt.
I understand your lordship's anxiety. Yeah, on this point. That is why,
Problem doesn't seem to be going away.
my lord, what happened? Leading will come when? When there is a legally received information for the first time. They must have received some information for the first time, which gives the police to ask me to lead them.
That's the information. They said they knew.
No, That is why, if that information already came to them, if they could have availed that information and taken the person who has given the information to the site, that could have been recovered that time also. If not, things would have different. Things would have gone different.
That is another matter.
Well, my respectful submission is that the whole authority, the whole occasion, the power invoked by police is on the basis of that information. The information leads to discovery. That is why.
Mr. Mahato, just let us, we are debating on a very critical and interesting point. Therefore, your research will say was very deep and certainly brings into the table some very important perspective
I'm grateful.
and actually has set us thinking. But we cannot stop halfway. We have to
Yes.
go the full length. Now, let us look at the logic behind 25, 26, and 27.
Yes.
Let us look at the logic.
Yes.
The logic is that 25 puts a bar because there is a presumption that any confession, any inculpatory statement made by an accused in police custody is never going to be voluntary. It will be extracted by
Yes.
threat and coercion.
Yes.
So if he says, I have committed the crime, that cannot mean he has done it. So it will have no evidentiary value. 26, there is a rider in presence of magistrate. That is also aimed at ensuring that there is a voluntariness, element of voluntariness in the
Yes.
state.
Yes.
But 27 makes an exception. Why? Because even if on being thrashed, the accused says this, even then it will not be vitiated. The reason is, unless it is the accused who says where he has hidden the weapon of crime or whatever else, whether he says it voluntarily or on being thrashed, that doesn't matter. The accused has to say it. Nobody else can say that.
But then, my lord,
Nobody else can say that.
the interpretation as given.
No, we're coming to that.
Yes,
We're
my lord,
coming
say
to that.
for that part only.
Coming to that.
Yes.
So while 25 and 26 puts us thick screen
Yes.
because there is a suspicion on the voluntary element of the statement.
And that remains.
That remains. But in 27, there is no question of voluntary or involuntary.
No, my lord, that is why in my
Because
submission,
he
the
must
interpretation
have-
goes otherwise.
He must have said it. Unless he says it, how will the police know where the dead body is
True.
hidden?
That he made a voluntary disclosure.
No, this is not required. Voluntary is not.
But therefore, to that extent, there must be independent notices, otherwise section 100, subsection 4, 5, all
That
these
is
will
where
come.
we have a disagreement with you.
My lord,
No,
let
no
us
need of
go to-
voluntary
my lord, otherwise it will infringe Article 23, Article 27.
Mr. Mohanto,
Three.
please take note of what we're saying. We may actually end up developing the law a little bit, and particularly with your level of eminence, I'm sure something more will come out. There is no need for a discovery statement under under section 27 to be voluntary. The fact that it is made by the accused and by nobody else, the greatest proof is that the articles are recovered from that hidden space.
True,
That is why.
yes.
There is no need
Recovery
to-
was, that gives the sanctity. That his statement came to be true because recovery was made.
Yes.
And therefore it says, my lord, first part, that the information must be received in the first instance. That information must subsequently
Alright,
materialize.
see, there is a, see, these are two different things we are talking about. Of
But
course, if the
intermediate-
police had the knowledge that the shirt was hidden in the jungle,
Yes.
your argument is accepted.
Yes.
But there is no such statement. They only said, we know, we can show you where the shirt is.
Yes, the place.
There is, this,
Discovery is the
accused never
place.
said where it is.
Discovery is the place. Information is that we have kept it concealed in a place. What is that place?
What is
It
that place?
discovered.
The police did not know then. They only said we can show you.
No, my lord, that information first came from other person that they can show it. He can also show it. Then it came that I can also show it. Had it been the case, would it that we can think of the supposing, my lord, without taking the statement under section 27 from my client. On the basis of the statement disclosure made by the first accused, he has taken him and me together and gone there, and it is recovered. Now, who will be sustained with this recovery? At whose instance it is made? If it is done, then at whose instance? I am also there, he is also there. The information was first obtained from him.
All right. So that part is taken. What is the second point?
So therefore, my lord, my response submission. This is very crucial. Second point. Yes. Now, here kindly see. The disclosure has led to the finding of the search. Now, whether that seizure was proved legally. If this seizure is not proved legally, again it will fall through. Place is shown, they have recovered certain object. That the object was recovered from that point, this is another requirement to be established with independent witness. Here it is not there. Here it is not there. They have examined one. The father says, police came and told me that this is what has been recovered from there. I have put my signature. And the other witness says, I was coming, I'm a resident of a place about 3 to 4 kilometers away. And I was on that day coming toward that direction and saw police and all these people are going towards, I accompanied them. And suddenly,
Two signatures are there.
but this cannot inspire confidence. That's why the court says that no, here independent witness you must bring in. Section 100, subsection 4 and 5 is applicable. CRPC. How to make a search and seizure.
Exhibit 2 is the seizure list of that shot.
My lord, my lord.
Who are the witnesses in exhibit?
The
2?
father,
1 and 9, they are.
father, first the father, and the 9 is the
1 and 9.
son's witness. He suddenly happened to come, Abdul Malik.
1 and 9.
1 and 9. One is the father, sorry.
1 and 4.
1 and 4, sorry. Abdul Malik 4. PW 4.
So he is an independent witness.
He is an independent witness. My absolute submission is, my lord, he doesn't meet the requirement of law. He cannot be said to be an independent. He is a son's witness. Son's witness is suddenly, can it so happen? Lordship will believe it, that on the date of seizure, someone suddenly appearing on this state and police just taken. What is it the case that there was no other person, local persons, competent persons to be the witness? That is what the requirement of law. Kindly look into 104. Now I go to that extent. But Apex Court has also elaborated it, but section CRPC 100, section 104, what it says. We cannot just brush aside all these requirements because it ensures the fairness. It inspires confidence so that the people have faith on the system, how it proceeds. And it says persons in charge of closed place to allow search. Then we will go to 4.
You're referring to section 104 of,
No, well, 100, section 100, subsection 4. CFS. It is regarding search and seizure. Before making a search under this chapter, the officer or other person about to make it shall call upon two or more independent and respectable inhabitants of the locality in which the place to be searched is situate, or of any other locality if no such inhabitant of the said locality is available, or is willing to be a witness to the search, to attend and witness the search, and may issue an order in writing to them, or any of them so to do. This requires that a respectable person from the locality should be there. He may be informed beforehand with a notice also that you please be there. We understand that without giving a notice, if someone from the locality is taken, it's another issue. But here kindly see that PW4, he says that I stay somewhere else. I was coming by bicycle on the road. I found that police is going along with these people. I accompanied them. And in my presence, this happened. And I put my signature.
so your submission is that somebody was going, stop, tell him to be, no, that will not be.
That will not
The
be.
police will have to go,
No,
get
not
someone,
necessarily.
and then
My
if he signs,
My lord, I do not say to that extent. Police must explore that he is acting within the bounds of the law. They must know that someone within the locality who is aware about, who has a reason to believe that he knows about the whole incident, and there is police is coming there, and they are making a search. I am a resident of that place. They did it. Someone suddenly appearing in the site, and just he and no other person, to the exclusion of everyone in the locality. There are so many people. That is what my point is. Someone suddenly appearing in the scene, giving an explanation, I was coming by bicycle, or
so
nothing.
what is wrong with it?
It is wrong because it doesn't inspire confidence.
Whose
It
confidence?
cannot be believed.
Whose confidence?
Well, legal confidence, dishonorable court's confidence, people's confidence. Well, we are all there, and the situation, something has happened there. We are all here. Police has taken someone from the street and taken the. What will happen? What about these people? They were all there. What no? Why not you wanted someone from there, here in the locality who were available there? That is why I say, my lord, that is why law requires that you follow these procedures. It will ensure fairness. It will ensure fairness. All right. That is why my sole submission is, father has his own, father evidence is of no use for one, for that seizure, exhibit 2. And this person only, and he also doesn't fulfill the requirement of law. Here, education also, na? Here, my lord, I will rely upon the decision rendered in Rajesh and another versus State of Madhya Pradesh. Criminal Appeal 795 of 2022.
Yes.
2022, 3 judges bench. Para 28. Page 22, my lord.
Yes.
Let's have got it, my lord. 28 paragraph, page 22. That I'm reading, my lord. Apart, the manner in which the investigating officer went about drawing up the proceedings, forms, and important issues in itself, and is equally debilitative to the prosecution's case. In Yaqub Abdul Razak Memon and so and so, this court noted that the primary intention behind the Panchnama is to guard against possible tricks and unfair dealings on the part of the officers entrusted with the execution of the search, and also to ensure that everything incriminating which may be said to have been found in the premises searched was really found there and was not introduced or planted by the officers of the search party. It was further noted that the legislative intent was to control and check these malpractices of the officers by making the presence of independent and respectable persons compulsory for search. Kindly see, respectable persons compulsory for search of a place and seizure of an article. It was pointed out that a Panchnama can be used as corroborative evidence in the court when the respectable person who is a witness thereto gives evidence in the court of law under section 157 of the Evidence Act. This court noted that section 104 to section 100 subsection A CRPC stipulates the procedure with regard to search in the presence of two or more respectable and independent persons, preferably from the same locality, so as to build confidence and the feeling of safety and security against the public, amongst the public. The following mandatory conditions were called out from section 100 CRPC for the purpose of valid Panchnama. A. All the necessary steps for personal search of officers, inspecting officer, and punch witnesses should be taken to create confidence in the mind of court, as nothing is implanted and true search has been made and things seized were found real. Well, pausing for a moment. Things are not going in that way all the time in the field, the way the legislature thought, the way the court wants, way the people want. That is why some more caution is required, and that is why these laws. Therefore, the whole approach, the legal approach, legislature has made the law with a little bit of bent of mind that police cannot be given the free hand and cannot be trusted all the time. There is every possibility of abuse, access, and this normally happens. There are so many custodial deaths.
That you are right.
Yeah.
See, these procedures are well laid down. But
Therefore,
in criminal cases, each case will have to be decided on
Exactly,
particular facts.
exactly. That
Ultimately,
is not
facts-
dispute at all.
Even if in some cases, if all these procedures are complied with,
Yes.
even then we may find
Yeah,
that
exactly. Well, then in that case, one can be safe and sure that everything that
So what
procedural
we are saying is,
justice.
even if all procedures, say there is a smart IO,
Yes.
he complies with all procedures,
Yes,
but there is something suspicious about the case.
exactly. Then
We
also.
will acquit it.
Yes.
Likewise, there
Because-
could be a case where the IO might have done everything and it might be a genuine case, but some lapses here and there.
Those
That
not
cannot be-
resulting in prejudice, those not casting a serious doubt.
Correct.
Then in that case,
So
obviously.
what is the play? What is wrong with PW4? You have not posed any question to him that he did not sign it, he did it on dictates.
Yes.
Nothing was told. During his evidence, what is the cross of PW4? Is there a suggestion that this was not recovered or he did not sign it? Exactly.
PW4.
Yes.
Let us see, my lord.
Hmm.
Cross at page 19.
Yes.
My house is at a distance of 3 kilometers away
Hmm.
from the house of Ilyas Ali. He is not my relative. I do not know where from Ilyas Master married his wife. The moment I got down at the village path, I saw the accused persons led police and other people to the place of occurrence. Other people are also there. I saw Ilyas Master, Amjad Ali, and 4-5 of his family members, others, and police at the relevant time. Police did not ask me regarding the occurrence. I do not know how the occurrence took place. Police did not ask me whether the accused persons confessed that they had committed the crime in order to demand ransom from Ilyas Master. It is not a fact that I am falsely deposing that the accused persons led the police to the place of occurrence and showed the shirt of the deceased cap concealed under a bush, and police seized the same in my presence. This assertion was good. The shirt is full shirt. The same color shirt may be available in the market, but material exhibit 1 is the said shirt which I had seen at the place of occurrence being seized by police.
So he has been firm.
He
There's
says,
nothing- He is
Malad-
completely firm on his testimony.
well, he says this particular line. It is available in market also.
That too, every
That is-
shirt is available in market.
Well, that is why the apex court has so taken care of this. Well, I may read
All right, all right.
little more. Kindly see that particular decision I was placing. This, এইটো যে পঢ়ি আছিলো এতিয়া, এইটো কি কৰিলা? নহয়, নহয়, এইটোতে না? এইটোতে. These conditions have been put. After all, my lord, my responsible submission is, there are other people also with them. Hopefully, those are from the same locality. He says that there are other people also from the same locality. Why not any one of them was taken? That's why my question
Yes.
is, it's a serious doubt.
All right, next point,
Serious
please.
doubt.
Next point.
Of the recovered object and incident.
My lord, here, another case, I will cite. How Panchanama is to be prepared. In that case itself, my lord, I will just point out one more thing. That case we were reading, my lord. All these A, B, C, D, E, F, G, up to H, the court has said. Regarding procedure was given much emphasis by the apex court, because 162 was referred to CRPC, page 24. Then Ramanand was also referred to. And ultimately, I will just refer to paragraph 30. In Khat Singh versus Union of India, this court held that even if there is a procedural illegality in conducting the search and seizure, the evidence collected thereby would not become inadmissible, and the court would consider all the circumstances to find out whether any serious prejudice has been caused to the accused. That is what I placed before this court. Question of prejudice has to be seen. However, this court pointed out that if the search and seizure were in complete defiance of the law and procedure, and there was any possibility of the evidence collected having been tampered with or interpolated during the course of such search and seizure, then that evidence could not be admitted. This question has also been put. So therefore, every case has to be decided.
All right.
Now, here is the case, therefore my full submission. In presence of all the other persons there, police opted for this person.
All right.
Therefore, there is no independent
There is a
evidence.
suspicion.
So seizure to that extent is not proved. Now comes this second point. If the seizure is not proved, this is one part, then whole thing falls through. Again, the chart is identified. That's all. Now, whether this was connected with the crime, police is to prove it. This is another part for the police to prove. Prosecution will have to show that yes, this which was recovered, this was used in the commission of the crime. They say, if we take it, that they gagged
Mr.
him out
Bhanda,
with the
sorry,
shirt.
we will just see, we have to close it now.
Yeah.
Those things have been done. The father of the victim has identified. We are not going into.
No, shirt has been identified. That
So-
it was used.
Hmm.
That it was used in the commission of the crime.
Where is the question of using a shirt?
No,
The victim was wearing a shirt.
yes.
This shirt, according
No,
to
Malak,
them,
no.
was taken out.
It is in the,
By that, it was gagged and then the shirt was.
in the context of, in the context I am arguing, in the context of the seizure, if it falls through, It's not a legal seizure.
Correct. So you made your point.
Yes,
Move
then in that case, it has no relevance
on. All right. Yes,
to that extent, my lord.
you made your point.
I'm-
Yes.
Obliged, my lord. Now, kindly see at what time this recovery was made, another aspect, suspicious. After 14 days, they were visiting, police was visiting the site twice or thrice. So can this be another circumstance, mitigating situation, casting doubt in favor of the accused persons? Now, here, my lord, I am referring to the decision.
So, Mr. Mohan,
2022.
see, the problem is all these arguments we will not consider because the foundation is not laid. The foundation is, there is no suggestion to any of the witnesses.
My lord,
Can't help it, can't help it.
my lord, my response.
142 powers, Supreme
My
Court.
lord, my response assumption would be that this court will examine as a whole overall considerations. There may be, if supposing, yes, if defense has been able to find out, take out
No,
everything
defense is
very
not able to
minutely.
take out. No. Let us have the perspective correct. We are not saying defense has to prove anything.
No,
We are only saying
No.
the foundation has to be laid for you to make these arguments.
Well,
Otherwise, we will not consider.
foundation, whatever is laid
Hmm.
by the prosecution, I am to argue on that. Because my burden is to see, to establish before the honorable court that whether prosecution has been able to prove it beyond doubt. Question is beyond the iota of doubt. Whether these are sufficient, the way they have done, whether these are sufficient to come to a definite conclusion, unerringly pointing the guilt towards the accused persons, or there still remains
That is
something. There only I am on, my lord.
that we will see.
And
definitely.
that is why I am placing this, my lord. Even we take it because they admit that this was the recovery was made after 15 days. What prevented them? Why not could it be done? Does it leave any scope for planting it by the authority itself? Can we just think of that? Apex Court said, yes, there are these issues. You will have to consider. Therefore, I am placing full bench decision of the Apex Court.
2022.
Birendra alias Bijender alias Mandar versus State of Haryana. It is criminal appeal number 248 of 2010. Decided on Judge Bench Muller, 8/11/2021. Kindly come to paragraph 15, man. I will place 15, 16, 17, 19. The short question, 15 ballot. The short question that falls for our consideration is whether the conviction of the appellant on the strength of the purported disclosure statement and the recovery memo in the absence of any corroborative evidence can sustain. Pausing for a moment, my lord, my submission is there is no corroborative evidence. Those evidence are not of any use. We have implored ourselves with abounding pronouncements of this court on this point. It may be true that at times the court can convict an accused exclusively on the basis of his disclosure statement and the resultant recovery of inculpatory material. However, in order to sustain the guilt of such accused, the recovery should be unimpeachable and not be shrouded with elements of doubt. That is what I am emphasizing, my lord. We may hasten to add that circumstances such as one, the period of interval between the malfeasance and the disclosure, two, commonality of the recovered object and its availability in the market, three, the nature of the object and its relevance to the crime, case of transferability of the object, ease of transferability of the object, the testimony and trustworthiness of the attesting witnesses before the court and or other like factors are weighty considerations that in the gauging the intrinsic evidentiary value and credibility of the recovery, these cases have been referred to. 17, incontrovertibly, where the prosecution fails to inspire confidence in the manner and or content of the recovery with regard to its nexus to the alleged offense, the court ought to stress the benefit of doubt to the accused. It's nearly 3 centuries old cardinal principle of criminal jurisprudence that it is better that 10 guilty persons escape than that one innocent suffer. The doctrine of extending benefit of doubt to an accused, notwithstanding the period of a strong suspicion, holds its front on the premises that the acquittal of a guilty person constitutes a miscarriage of justice just as much as the conviction of the innocent. Therefore, my responsible submission is there is no such evidence here to convict, but it gives rise to suspicions. Suspicions that I was involved. That suspicion cannot partake the character of proof. And what are these circumstances, Lordship? Lastly, I want to just sum up after this again. Yes. This I referred to, but we didn't read, na? Probably. Decision, it took to decision. It will, na? And this judgment itself, Lordship may also see paragraph 19. Unmindful of these age-old parameters, we find that the prosecution in the present case has miserably failed to bring home the guilt of the appellant, and courts below have been unwittingly swayed by irrelevant considerations, such as the rise in the incidents of dacoity. In its desire to hold a heavy hand over such derelictions, the trial court and the high court have hastened to shift the burden on the appellant to elucidate how he bishops to be the possession of the incriminating articles without primarily scrutinizing the credibility and admissibility of the recovery, as well as the linkage to the misconduct. We say so in the following reasons. 1, 2, they have given so many reasons. Fifth, Lordship may see. Fifth, the recovery took place nearly a month after the commission of the alleged offense. We find it incredulous that the appellant during the entire time period kept both the red cloths and the passbook of his so-and-so. So this is one of the circumstances court took into account. And sixth, it says, and finally, there is no other evidence on record which even remotely points towards the iniquity of the appellant. So, another decision is Manoj Kumar Soni versus State of Madhya Pradesh, Juvenile Appeal 1030 of 2023, decided on 11th August 2023. One paragraph I will just point out. To your lordship, page 21 paragraph. In the other decision, we have found that regarding the probative value, that it has to be supported, then of course, this court says here, at paragraph 21, man, a doubt looms. Can disclosure statement per se, unaccompanied by any supporting evidence, be deemed adequate to secure a conviction? We find it implausible. Although disclosure statement holds significance as a contributing factor in unriddling a case, in our opinion, they are not so strong a piece of evidence sufficient on its own and without anything more to bring home the charges beyond reasonable doubts. Therefore, my lord, what are the other evidence here against the appellant? They are relying on certain circumstances only. Like yes. Here, I'll just sum up referring to the circumstances pointed out against me by the prosecution. What are those circumstances which on the basis of which they say that I'm involved in the commission? Firstly, that I was found playing cards along with the other accused persons and other boys near the place of occurrence. And that I left the place at 3 o'clock afternoon. 3:30. 3:30, I left the place. And that the other accused persons left the place at 5:30 p.m. 5:30 p.m. And another aspect is me and the other victim, the accused, Saiful, returned back to the same place together at 6:37. This was the only circumstances. So I was playing card, I admit. I left at 3:30. Thereafter, what I did, is there any evidence that thereafter both of them were, after 5:30 he left? Is it the case of the prosecution? Prosecution could not show that after 5:30, both of us were seen together. We came back together, but there is nothing to suggest that before that, at any point of time, we were together. We can come back together. That by itself cannot be a suspicion. It may be a suspicion, but it has no value at all. We may meet on the way, we can come and join. And the subsequent conduct. I was playing cards there till late hours. When they all heard the hue and cries in the house of the victim, they all came there. 7 o'clock, after 7 o'clock they heard, they all came there. And then police wanted him, he went there. Police called him, he went there. All right, yes, therefore, my response submission. There is nothing, not to speak of a chain of events, there is no circumstances which can anyway help the prosecution to bring home this charge against the appellant. My true submission. I'm grateful, my lord.
Only a few things that, first is that, this was the first statement that was made by Saiful and Khairul.
Hmm.
Saiful and Khairul made, statements about recovery only on 10th. I've checked their previous statements. They have not spoken anything about recovery. So recovery, this is the first statement on 10th and 11th it was recovered. And secondly, I've marked that, Lordship can see. And secondly, independent witness. Lordship can see one judgment of Supreme Court where it is said no independent witness is required in case while recording recovery statement. That is not the law under section 27. This is that Praveen Kumar versus state of Rajasthan, no? Praveen Kumar versus, this is paragraph 27. Lordship will go to paragraph 27. No, 21. Paragraph 21. Straight away to paragraph 21. Then Lordship got.
Yes, yes.
Section 27 does not lay down that the statement made to a police officer should always be in the presence of independent witness. Normally, in cases where the evidence is led by the prosecution as to a fact depends solely on the police witness, the court seeks corroboration as a matter of caution and not as a matter of rule. That thus it is only a rule of prudence which makes the court to seek corroboration from independent sources. In such case, while satisfied that the evidence of police can be independently relied upon, then in such cases there is no prohibition in law that it cannot be accepted without independent corroboration. In the instant case, nothing is brought on record to show that why evidence of 33 should be disbelieved in regard to the statement made by the accused as per Exhibit P35.
Alright.
So as far as this is concerned, there is no requirement. And on the law point, Lordship wanted to know on the earlier day, what about the confession and the information if it is not again discarded by the other witness? Lordship, Pulukuri Kotaya is clear on the point. Lordship will just see one paragraph there. Pulukuri Kotaya. I have marked that by small blue lines. Section 27. These, the first blue lines can be avoided. This is submissions. I have marked small two blue lines on the, because no Lordship, no Privy Council does not have paragraphs normally. This is Privy Council 47, Privy Council 67. Where Lordship will go to the next blue lines. The second question, which involves the construction of section 27 of Indian Evidence Act, will now be considered. The first blue lines consist of the submissions that the entire confession, the entire information will be considered. This was the submission which is negated by the Privy Council. That section and two preceding section with which it must be read are in these terms. 25, 26 and 27 of the evidence and continued. Section 27, which is not artistically worded, provides an exception to the prohibition imposed by the previous section and enables certain statements made by a person in police custody to be proved. The condition necessary to bring the section into operation is that the discovery of a fact in consequence of information received from a person accused of any offense in the custody of a police officer must be deposed to, and thereupon so much of the information as relates distinctly to the fact thereby discovered may be proved. The section seems to be based on the view that if a fact is actually discovered in consequence of the information was true, and accordingly it can be discovered in consequence of information given, some guarantee is afforded thereby that the information was true and accordingly can be safely allowed to be given in evidence. But clearly the extent of the information admissible must depend on the exact nature of the fact discovered to which such information is required to relate. Normally, the section is brought into operation when a person in police custody produces some place of concealment, some object such as a dead body, a weapon, or ornaments said to be connected with the crime to which the information is accused. Mr. Megaw for the Crown has argued that in such a case, fact discovered is the physical object produced and that any information which relates distinctly to that object can be proved. On this view, information given by a person that a body produces that of a person murdered by him, that a weapon produces the one used by him, or the ornaments produced were stolen in custody would all be admissible. If this is the effect of 27, little substance would remain in the ban imposed by the two preceding sections on confessions made to the police or by person in police custody. That ban was presumably inspired by the fear of the legislature that a person under police influence might be induced to confess by the exercise of undue pressure. But if all that is required to lift the ban be the inclusion in the confession or information relating to an object subsequently produced, it seems reasonable to suppose that the persuasive powers of the police will prove equal to the occasion, and then in practice the ban will lose its effect. On normal principles of construction, their lordship thinks that the proviso to 26 added by 27 should not be held to nullify the substance of the section. In their lordship's view, it is fallacious to treat the fact discovered within the section as equivalent to the object produced. The fact discovered embraces the place from which the object is produced, and the knowledge of the accused to this and the information given must relate distinctly to this fact. Information as to the past user, past history, the object produced is not related to its discovery in the setting which it is discovered. Information supplied by a person in custody, I'll produce a knife. Knives were recovered so and so, lordship will skip. It leads to discovery of the fact that the knife is concealed in the house of the informant to his knowledge. And if the knife is proved to have been used in the commission, the fact, but if to the statement the words be added with which I stabbed A, these words are inadmissible, which they do not relate to the discovery of the knife in the house of the informant. So what the Privy Council said, if we take the entire statement of confession, 25, 26 will get nullified. So only distinctly related. So that is the discovery statement. And in fact, my learned friend had also said another judgment, lordship, just 1-2 paragraphs, Mehboob Ali. This has also made it very clear. 2016, 14 SEC, 640, 13 and 17. Mehboob Ali. To go to paragraph 13 and 17. For application of section 27 of Evidence Act, admissible portion of confessional statement, lordship.
Yes.
Lordship hands. Paragraph 13. For application of 27 Evidence Act, admissible portion of confessional statement has to be found as to a fact which were immediate cause of the discovery. Only that would be the part of legal evidence and not the rest. In a statement, if something new is discovered or recovered from the accused which is not in the knowledge of the police before disclosure statement of the accused is recorded, is admissible in the evidence. Lordship can also see paragraph 17 once. And Lordship will not see 17. Again, Kotaya, Inayatullah, all these judgments are referred. Lordship has already seen.
Yes.
These are the two that I wanted. There are other similar judgments. I'll not bother your lordships. And as far as the circumstances are concerned, lordship, I have already said on the other day. This is my humble submission.
Take down, heard Mr. K.K. Mandal and senior counsel listed by Ms. N. Begum, learned counsel appearing for the appellant in item 20. Also heard Ms. B. Sharma, learned amicus curiae. Anything you want to add? Amicus curiae appearing for the appellant in item 19. Ms. S. Jahan, learned APP Assam, has appeared for the state in both these appeals. Mr. B. Chetri, learned counsel for the informant, is present. Is also present. Arguments concluded, judgment reserved.
Deeply applies.
Separate finding. Yes, yes.
One lordship's judgment is there, Madam Jalaluddin.
Jalaluddin, that case where the vehicle was, the body was found after 1 month, vehicle found in
Corpus
Karimganj
delicti.
on larceny theory.
Corpus delicti. Last theory.
Circumstantial evidence and larceny.
Larceny theory cannot be the sole basis. It will have to be.
The lordship has decided.
Yes. Lost in theory, of course, it doesn't come in my case. I was
Yes.
never seen.
As far as Saiful, it comes.
The corroboration.
Yes, for the government, another, Mrs. Yes, just call it. We should improve this. Bye-bye.
Supplementary list for hearing item 30.
So in this case, we heard the matter.
As Roy's matter.
Yes,
Yes.
there she is.
Uh-huh.
Only question was, that was a question put by the court. Why the wife was not examined.
Yes.
We also find on a deeper scrutiny that no witness has mentioned about her presence. On the contrary, there is some evidence to show that there was a quarrel between the deceased and the accused. So therefore, whether the wife was at all present in the place or not, that itself is not established. Under these circumstances, to say that the prosecution has failed to examine a material witness and there should be adverse presumption, that cannot be drawn.
Will not come.
But why did you rely on Manish Dixit and others?
Manish Dixit says that if the sole witness was not eyewitness not examined, Lordship can go to circumstantial evidence.
Where is the paragraph?
Lordship. Manish Dixit, paragraph. Because Manish Dixit, in the fact of that case, he was a national of Germany and he left for Germany.
And the police allowed him to leave and then he never turned. So
Yes,
there-
and he could not be examined. And so matter proceeded on circumstantial evidence. Manish Dixit, Lordship will go to paragraph 11.
Hmm. All right.
Lordship. Now here is a case of circumstantial.
Anything else?
There is no motive in this case, my lord.
Motive.
In circumstances, evidence, of course, motive I need to establish. But there was a quarrel between the two.
No,
But if there is a quarrel, will it be a case of 304 part 2?
But then there was no plea of quarrel. I mean, that has not come in the evidence. Neither they have stated in 313.
rather PW4 stated that
Because,
this is
yes.
under the condition of liquor and he might be killed by other person. PW.
No, that part.
Quarrel part is only there in PW2 statement. Lordship can see once PW2. At the time of incident, there was a quarrel between the accused, but then he was in the shop. He came after hearing cries. And then he saw the body lying and he was with the bottle. But then he was nearby, his shop was nearest. And so he, of course, not in so many words, he did not say, I heard the quarrel. But then he said at the time of incident, there was a quarrel between the accused and his wife and a deceased. And a deceased tried to intervene in the said quarrel. Again, in his cross-examination, he said, it is not a fact. I falsely stated that at the time there was a quarrel. So that quarrel part is only in the evidence of PW2. That way, Lordship can bring it down.
Bring it out as?
Bring it down, the punishment.
That will be too presumptuous.
But too presumptuous. And in 161 also he spoke about quarrel.
Who?
PW2.
PW2.
Although trial court wrote
No,
there
trial
is
court
nothing
said-
in 161, but I've checked in 161, he said about the quarrel.
Did he see the quarrel himself or he
No,
heard? of
that
it?
in so many words, it's not there. But his shop is the nearest to the place of occurrence.
No, he was working in the neighboring place.
PW2
PW2.
or Ranjit Boro, yes, he was working in the neighboring house.
Hmm.
PW1 shop is.
Only thing is, these two witnesses have mentioned about having heard or the sound of a quarrel or something. We'll see. Next matter.
Not. Lordship has saved the verdict.
Let's see, we'll try to write it out today itself.
Item 28.
Lordship, I've gone through. Earlier judgment, Lordship, while remanding the matter back, the Honorable Court did not interfere with the order of conviction. Then, my lord, then thereafter, the present impugned judgment was passed after taking into account the deposition of the doctor. Lordship, may I say, although admittedly nothing, Lordship, no, Lordship, against the other accused person who has been acquitted, no material as such was there. As such, I have no objection against acquitting her. But against the present appellant, although there are same set of evidence, your Lordship may still interfere with the order of conviction. May take into account the entire evidence on record, my lord, as against the accused person. I'll be relying on two judgments. So, Lordship, if your Lordship takes up today or some other day, I'll leave it to your Lordship.
No, what is your submission? That
My submission is
evidence
that
is the
although evidence is same, section 30234 was there along with 120B, no? Yes. So one of the accused person is acquitted, another is there. Still, your Lordship, 302 simpliciter will lie, my lord. I have got three judgments to that effect.
But yesterday he gave us a judgment. That judgment.
Yes, madam.
That is very clear.
Javed Shaukat Ali, madam.
One judgment, case or no?
Do
Oh. I have got 1, 2, 3, 4, 5, 6 Constitution bench judgment.
6. What,
1955, A 1956, SC 116.
what is the point?
Lordship, as regards whether when two accused persons are there, whether 302 simpliciter will lie. Court can still act on it, man.
No, that's not the point. The point is, it is the same evidence.
Same evidence, my lord.
By mistake or unwittingly, we can't comment on
My
that.
lord.
But the earlier division benches acquitted the co-accused.
Yes.
It is the same evidence now. So if we maintain the conviction, then it will turn out that the High Court has acquitted co-accused on the same evidence.
Lordship, reason has been cited in the earlier judgment.
Yes.
My lord.
What is the reason?
Lordship. Lordship, page 5, para 11, page 4. The conviction in this case is just based on extrajudicial confession of the accused Shamal Paul and discovery of the dead body at his instance. The doctor who held postmortem examination on the dead body of the deceased was not examined as witness, and therefore the postmortem examination report has not been brought on record. Defense side did not get any opportunity to challenge the finding of the doctor as regards date of the deceased. Only PW1 has stated that both the accused confessed before the police that they had killed the deceased. The confession report of the police is not admissible in law, and none of the other witnesses have stated that both the accused made any extrajudicial confession. According to them, only the accused Shamal Paul, present appellant, my lord, confessed that he killed the deceased. It was thus accused Shamal Paul who led the police, and the dead body was recovered at his instance only. Therefore, the conviction of the accused Sumita Paul is based only on assumption and not on admissible evidence. The conviction of Sumitra was therefore liable to be set aside. Here, your lordship, extrajudicial confession is made to 3 of the witnesses who are independent, my lord, VDP secretaries. And your lordship, one of the witnesses related to the accused person, appellant, and there was leading to discovery. These 2 factors, my lord.
So what is your submission?
My submission is the lordship may hear the appeal.
Well, I have got other points also, madam. This is one of the points, which we just want to
Then
lordship.
it has to be heard then.
There are other points also because apparently, my lord, this witnesses, extrajudicial confessions, these persons are not of sterling quality, number one. And secondly, there is a lacuna in the way the body was recovered, madam. That's not been, the procedure has not all been followed, madam. I'm relying upon some recent judgments, madam, where, my lord, it is said, my lord, that the confession statements have to be recorded in a particular manner, my lord, by the police. And the discovery, there has to be punch witnesses has to be there. All these things have not been followed at all.
So extrajudicial confession is only about Shamal Pal.
Shamal Pal, my lord. And that too, my lord, I'll show, my lord, there's
It can't be said that there is same evidence.
well, maybe, my lord, that's true, but that part is of course there, my lord.
Then let it be heard after 2 weeks.
As your lordship pleases, my lord.
I had Mr. M. Dattal and counsel appearing for the You're appearing as amicus.
Amicus, otherwise I'm ready today also, if the lordship wants to hear.
Our hands are full.
My lord,
Who
as a
writes
lordship, yes, as a lordship.
Appearing for the appellant also had Ms. B. Bhuyal and FPP Assam, appearing for the state, who submits that this appeal be posted for hearing on some other day. In view of the above, we adjourn the hearing of this appeal by 2 weeks, register to list the matter.
Matters.
So from the. Three.
Item 29.
How many more matters? We can't. Oh, Mr. Mahajan, you're waiting for which item?
24.
It has to go because from Monday, the bench is changing. Please ask your junior to take a date. Yes. So, very short point here is the age of the appellant has been found to be 20 years on the date of the occurrence. So the learned trial court has given 2 years relaxation, 2 years. You are saying beyond 2 years, another 1 year. That's your argument?
Yes, as per rule two.
And in support of your argument, you have relied on the decision.
Yes.
Correct.
Yes.
Mr. Kael's argument is that the maximum relaxation permissible has already been given. So further 1 year relaxation is not admissible under the rules. That's the point. Now, today the issue is stuck up in IA criminal because if he is held to be a juvenile, then this appeal will have to be dropped. Otherwise, the appeal will have to be heard.
Yes.
So today the appeal cannot be heard. We have to only hear on the point of the IA
Yes.
and take a decision. That's correct?
Yes, Lordship.
So 5 minutes,
Yes, Lordship.
conclude.
Lordship, in
Further,
this,
my argument is that even if Lordship thought that he was a juvenile, under the facts and circumstances of the case, he is not entitled to benefit. I am relying on thin judgment. I have given the copy of your Lordship.
before that, Lordship, because whole, on 18 to 2021, the direction was passed by the Honorable Court to conduct the ossification test as per Rule 12 of Rules 2007. So accordingly, the trial court conducted the ossification.
Those we are aware. You don't have to go
Lordship.
into all those things.
But Lordship, after that Rule 12, I have Xerox this copy because I did not get the book, whole book.
How much time will you require?
No, so I have made my submission in writing
All right.
because that is Lordship, it is statutory provision.
There is a
Lordship.
written submission. You have made written argument.
Small effort I have made.
That's okay. All right.
Synopsis to develop.
So there is only one thing which is in your favor.
Yes.
That is the judgment authored by
Yes.
Honorable Justice T.S. Thakur.
Yes.
Apart from that,
And one more judgment I have placed before this Honorable Court that Asin Kumar 2012 9 SCC and 2022 I found one judgment, Lordship, that is Vinod Katara. Vinod Katara, all these things took up Lordship and discussed, Lordship.
What is the ultimate?
Ultimate decision in Vinod Katara because the direction was passed to the trial court to verify the document, all these
So
things.
that is fine. Where determination is made.
Yes,
Here
Right.
determination is made on the basis of an ossification test.
Yes,
And now, in terms of 2007 rules.
yes,
Benefit can be granted for 1 year.
yes,
Okay, in some judgments, it says that it is 2 years.
yes.
So even if it is 2 years is granted, it will not come within below 18 years, 3 months and something.
After
So
that,
therefore, your whole plea is that it should be given two
Plus
plus
one.
one.
because of discharging.
Because
If two,
subsequent in 2094, section 94, there is no prescription as
Yes.
regards that.
yes,
benefit.
I do agree with your lordship. Yes,
So
that-
therefore, you are arguing that I am entitled for benefit under the rule 12 of the 2007.
Seven.
rules.
yes, lordship.
This is your.
Yes,
In that case, this is 1 year. And
Yes.
at the same time, you are saying that it should be 2 years are being granted by Supreme Court, therefore 2 plus 1, 3. This is your case.
yes. And if two views are possible, then in that case, if two views are possible, lordship, to
What is the judgment 2 plus 1? I am not getting in this.
2 plus 1,
That's
that
addition.
it is Dargaram 2015 to SCC. Kali. Yesterday I placed the judgment, lordship. It was indeed.
Give that judgment. Dargaram.
Yes. The person. What doesn't know. Paragraph number.
Paragraph.
Paragraph, lordship, my copy placed. Paragraph number. So 15, 16 and 17. In 17 last part. Assess, what was- assess. 16 last part, lordship. 17 last part. See.
There are judgments beyond 30, many judgments should be good. Beyond 30 years, ossification state is having no value.
I'm not on 30, because
So then in this case, determination was made after 35 years.
but that has been discussed, lordship, in Binod Katara case, lordship. That is followed. Binod Katara.
What are your judgments? You have given it.
I've given 3 judgments, lordship.
So according to you, first of all, he is not entitled to additional 1 year.
Yes, lordship.
Secondly, even if it is given,
Yes, lord.
even then the facts are such heinous
Yes, lord. He cannot
that
be.
he cannot be treated as a juvenile.
In 2022, Supreme Court has dealt with all these earlier judgments and come to finding that the benefit cannot be granted to such accused. And
But
here,
she's
lordship,
saying- But she is saying because that benefit is, that the classification is made under 2015 Act, section 15.
no, even the,
So therefore, she is saying 2007, there was no applicability of that.
It is.
no, even the lordship, whichever
Mm.
act is applicable, here, lordship, he will not be entitled to such benefit.
But one more thing is that I have placed one more judgment, that is lordship, Asin Kumar Saxena, that is 2012 9 SCC in paragraph number 40, kindly peruse that also. Lordship. I have placed the whole the things in my writings, lordship. Yeah, yes.
I heard Ms. Esken argue, IA criminal 116 of 2018. Heard Ms. Esken argue, learned counsel for the applicant, also heard Mr. S. Khan, learned counsel appearing for the respondent. Arguments heard in this IA order reserved.
I leave up to your lordship.
So we'll
New
see
thing may be come out, lordship.
Because these orders passed by these courts have a ramification this way or that way. It's not about one case. So therefore, we have to see what is the position. It will take a little time.
Lordship.
Why is all? One matter called?
এই জেরক্স করে দিয়েছে না এরকম মোটর কাপড় হয়েছে পাবলাইজ তো আছে
Also for the day, item 23. The prayer of learned counsel for the appellant, this matter stands adjourned for a week. This B. Buya learned epic person is present for the state. Yes. Anything else? Other matter, item 24. On the prayer of learned counsel for both the sides, hearing of this matter, item 24 stands adjourned. On the request of appellant's counsel, register to list this case again on put a date.